so I'm going to talk very briefly about the voluntary dispute resolution, mainly because I think I've only seen a strata corporation use it once. It's in the standard bylaws. In the standard when the Strata Property Act came into force, they included a provision that would allow strata corporations to have a bylaw that essentially would provide sort of informal mediation kind of services that are sort of managed within the entire community. And to facilitate that and to sort of give owners an idea of what that might look like, they included in the standard bylaws a provision that's called voluntary dispute resolution. And really, its name states, it has to be voluntary. So whoever's involved, like the owners in the strata corporation, or two owners, or an owner and a tenant, or whoever combination of those parties may be, they all have to be agreeable to doing this process. So that's usually one of the biggest impediments to this process, is that people don't all agree to it or aren't even aware that it exists. So that's the first part of it. The second is that it really has to be a dispute that involves what's set out in that bylaw. So it has to involve the Strata Property Act, the regulations, the bylaws, or rules. And what happens is, if there's a dispute, somebody would contact the council, for example, and say, I want to resolve this dispute through the voluntary dispute resolution. And if the Strata Corporation says, okay, we'll agree to that, then what happens is the party who suggested that to the council would say, okay, I want to appoint Jane Doe to be, who is an owner in the complex, to be my sort of nominee on the dispute resolution committee. And then the Strata Council would appoint somebody else as another nominee on the dispute resolution committee. And then those two people would find another person to be on that committee, and that other person chairs the committee. And then their mandate is to try to help end the dispute. They don't have any sort of, they can't make orders, they can't make decisions that are legally binding. All they do is going to try to facilitate communication between the parties in the hopes that they can come to a resolution. So, like I said, doesn't have the powers to make a binding decision, and at any time in the process, either party can decide, well, forget about it, this isn't working, I'm not liking this, we're going to go to court or to tribunal to try to resolve our dispute anyways. The other thing to note is that the whole process is without prejudice. And if you've ever been involved in anything legal, you'll know that without prejudice means that you're able to freely speak without worrying that what you say in those meetings will be used against you in a court or a tribunal. And same thing, if you create documents or that include things, or they're not part of your strata records, but if you create the documents for the purposes of this process, those documents can't be used against you. So it's meant to essentially allow the freedom of communication to try to come to a resolution. Okay, so arbitration. Arbitration has fallen out of fashion. Arbitration used to be something a little more common, but I think with the Civil Resolution Tribunal, most parties don't bother with arbitration. One of the reasons I would assume is because Civil Resolution Tribunal, you have somebody making the decision, and it doesn't cost, you don't have to pay that person. In an arbitration situation, you actually pay the arbitrator to resolve your dispute for you. Similar to the Civil Resolution Tribunal, the things that can be submitted to arbitration are things like the interpretation or application of the Strata Property Act, the regulations, the bylaws or rules, issues that relate to common property and common assets, use or enjoyment of a strata lot, money that's owing by an owner or tenant, an action or threatened action or decision by the Strata Corporation, including the Strata Council, in relation to a tenant or owner, and the exercise of voting rights by a person who holds more than 50% of the Strata Corporation's votes, including proxies at a general meeting. Now, there's certain things that you cannot arbitrate. That's things that where the dispute resolution mechanism under the Residential Tenancy Act applies. You can't do that. If the parties have all agreed that it's supposed to be resolved by the Commercial Arbitration Act, you'll see that sometimes in strata corporations that have cost-sharing agreements and easements where there's some cost-sharing agreements, some of those talk about resolving disputes pursuant to the Commercial Arbitration Act. It means even though you didn't agree to it, if it's in the document that any dispute is to be resolved under the Commercial Arbitration Act, you won't be able to use the strata corporation arbitration process, or actually the Civil Resolution Tribunal. So the Commercial Arbitration Act is a separate process than the arbitration that's available under the Strata Property Act. The Commercial Arbitration Act has some pretty formal rules, and they starts to look a lot like court process. The arbitration provisions under the Strata Property Act were meant to be a lot more flexible to allow an arbitrator to come in and set up a dispute resolution process that may make sense for the type of dispute or the nature of the claim. So it's a little bit different. And the other time you can't start an arbitration under the Strata Property Act is if you've already got a court proceeding regarding the dispute. So if it's already under the jurisdiction of a court, you can't start an arbitration. Okay, like I said, this is now kind of fallen out of favor, so we don't see as many of these as we used to, though they still come up from time to time. So how's the arbitrator chosen? The claimant ends up providing a document called a Form L, and in that they suggest who they want to be as an arbitrator. They can suggest one person or a list of people, or if they don't really know, they can come up with a method for choosing the arbitrator. Then the respondent would respond back with their own form saying whether they agree to any of those arbitrators or the method of appointing the arbitrator, or if they don't agree, they would provide their own list or their own method for choosing an arbitrator. And then if nobody agrees by this point in time, then each party gets to appoint their own arbitrator. And then those two, kind of like the Voluntary Dispute Resolution Committee, those two pick a third arbitrator, and then they decide amongst themselves whether they're going to have an arbitration of a panel of 3, or the arbitration is just going to be handled by that third arbitrator that gets chosen. And as you can well imagine, if you end up with a panel of 3, it ends up being really expensive, so because you're paying for all of those arbitrators' time.